contributing on pension scheme will be limited to the base salary. But under para 11.3 of the pension scheme, the employer and employee joint declaration is required for contributing in the pension on higher salary. If they contribute on higher salary, their pensionable salary for fetching the higher pension will be permissible. As regards the para 11.4, this is a new provision added after the amendment of effective from 1st September 2014. In fact, in this para 11.4, all the employees who were contributing and had exercise option under earlier 11.3 were again were asked to give a further joint option to continue on and continue for contributing on higher salary after the amendment. According to this para, they were given an additional liability of 1.16% of the salary for contributing in the pension fund. A very important provision was also inserted. If the employees who have opted under para 11.3 and not opted under para 11 subclause 4 within the specified period, that's within 6 months or further extendable to further 6 months with the permission or UFC, their contribution on their higher contribution or higher salary in the pension fund was required to be diverted back in the provident fund. Means in future they were not allowed to contribute on higher salary. That is the very significant para 11.4. Thank you.
Thank you, Mr. Pandey. I think people on the call on the webinar must have some idea about para 11.3 and 11. Now let me go to our another panelist, Rashmi. So Rashmi, again, 1st September 2014 is the date which is coming here. What is the relevance of that? Can you please enlighten everyone on the call, why this 2014 has been specifically provided?
Right, thanks, Akhil. So, as we have already mentioned, the EPF scheme, the EPS scheme was brought into place in 1995. In 2014, for the first time, the EPS scheme was amended, and the amended provisions were to be applicable from 1st September 2014. So that is the relevance of this date, 1st September 2014, because based on this, the employees are going to be put into different segments, different permutations, combinations can arise. On the screen itself, we are seeing the two segments over here. Employees who retired before 1st September 2014 is one category they have mentioned over here. They have mentioned employees who were in service prior to 1st September 2014, but continued to be in service on or after 1st September 2014. So that's another category they have made. So therefore, we will see in the slides in going ahead how this date is relevant and how this impacts each of us who are probably on this call or otherwise, in terms of whether we are eligible to exercise the option for higher pensionable salary. Does the Supreme Court decision impact us? So these are the points which will be covered with reference to para 11.3, and 11.4, which Mr. Pandey has explained, and with reference to this date of implementation of the amended scheme from 2014 onwards.
Thanks, Ashley. I think lots to look around in the coming slides. I think with this background, let's move ahead to understand what are the changes introduced by 2014 amendment. And let me ask Ashley to continue guiding us with the changes because there are a lot of things to understand and deliver on. Yeah.
Right. Thanks, Akhil. Right. So continuing the discussion, Mr. Pandey has helped set the context in terms of what para 11.3, 11.4 had, the significance, what is it that we are looking forward to from the 2014 amendment. So that's where the future, the next questions on eligibility will come into place. Now, we are discussing 5 key changes which were introduced in 2014, which had an impact on the contribution to employee pension scheme. The first change, the pensionable salary was increased from 6,500 per month to 15,000 per month. Second, the 2014 amendment required that employees who had exercised the option under para 11.3 of the 95 scheme and they would like to continue that higher contribution to pension. So, like we mentioned, under para 11.3, there was an option for employees to contribute to EPS on a higher wage salary. And if they had exercised that option and were contributing on a higher salary, the 2014 amendment required them to submit a fresh joint declaration for this purpose. Right? So a fresh joint declaration was supposed to be submitted by all those employees who were contributing on higher salary. Now, this fresh declaration was supposed to be submitted within 6 months of 1st September 2014. An additional time of 6 months was provided if, due to any reason, an employee is not able to submit that joint declaration. Additional time was given to submit the declaration under approval of the RPFC. So by taking this step, the employees could continue contributing to EPS on a higher salary. However, if the fresh option of the joint declaration was not exercised by the employees within this time period of 6 months plus extended time period of another 6 months, there was a deeming provision which 2014 amendment brought in. What this said is, if you had not exercised the option within the 6 month plus 6 month period, then it was deemed that the employee has not opted for contribution over the higher salary. Right? So in such cases, the mechanism provided was that the amount contributed to EPS over and above the wage ceiling will be diverted back to pension fund. So what we're looking at is employees were contributing on a higher salary, the amount was going into EPS, but if the joint declaration was not exercised, so employer might have been contributing to EPS on a higher salary, but joint declaration was not exercised, then it kind of reverts to the original position where EPS would be on the normal salary or the wage ceiling basis. So this was the second change which was brought in. Third, as per the framework of the 1995 scheme, the central government was contributing 1.16% of the wage ceiling towards the pension scheme. So this was 1.16% going not from the employer or the employee, but from the central government side on the wage ceiling of 6,500. Under the 95 scheme, those employees who had opted to contribute on a higher salary were not required to do anything else. There was no additional contribution from their side on this higher contribution. However, in the 2014 amendment, what the government brought in was those employees who are contributing on a higher salary, those employees also need to contribute 1.16% on the higher salary, to the extent of the higher salary. Now, where will this come from? In the beginning, Akhil, where he took the background, we mentioned that there's a 12% contribution by employee and a 12% contribution by employer. Employer's contribution is allocated in 2 parts, towards pension and towards provident fund. So we can see that in the PF Act or para 26 from that reference, employee contributing towards pension scheme is not really envisaged. But the 2014 amendment brought in this point to put this responsibility on the employees who are contributing on higher wage ceiling, that there is an additional contribution, that's the term used, the additional contribution towards the pension scheme. So this was the third change brought in by the 2014 amendment. Next, the formula to calculate the pension was changed. Under the 95 scheme, pension was calculated with reference to average salary of last 12 months. Under the 2014 amendment, the average salary was changed to 60 months. What this translates to is, there's a larger denominator here. So the amount of pension that a person would receive would obviously reduce when you take the last 5 years salary, because your salary would have, is expected to have increased over a period of time. So when we take 5 years average salary, the salary is likely to have reduced. So that was another change brought in by the 2014 amendment. And last key amendment was that before the amendment in the 1995 scheme, every person who became a member of the EPF was also a member of the EPS. So contribution to EPS was always there. It could be at the statutory ceiling, or if option was exercised under para 11(3), it could be on a higher salary as well. 2014 amendment brought a change in this and said employees joining after 1st September 2014 and whose wages are above the statutory ceiling of 15,000, they are not eligible for EPS membership. Those who had joined before 2014, who are already members of EPS, will continue to be members of EPS, but employees joining after 1st September 2014 and whose wages are more than the statutory ceiling will not be eligible to become members of the EPS. Right? So these were the 5 key changes that were brought in. Now, one would, the question that comes up is, from 1995 till 2014, the scheme was in place. Now, what possibly led or prompted the government to tamper with this or to bring in these provisions? So I'll request Mr. Pandey to share his thoughts or give us the context, the historical context, that why these amendments specifically were brought in to the employee pension scheme.
Thank you, Rajshri. In fact, basically this pension scheme was brought for the lower category employees, means those employees who were earning wages from a limited salary, and not for the person who are earning on a reasonably high salary. So it was for a low earner. But after in the 1996, through an amendment, the option was given to members to contribute on a higher salary also. But subsequently, it was felt by the EPFO while analyzing the fund that it has a strain due to higher outgo of the payout to the persons who are contributing on higher salary. Means there was a higher pension payable to person who are contributing on higher salary, and the funds, it was considered by EPFO, the funds may be duplicated and funds may not be sufficient to cater the provision, the pension for which it is required for. So they were considering various ways how to bring it to control. And ultimately, they thought that there must be some restriction to the person who are contributing on higher salary. So by the amendment, all the future persons who were earning on more than 15,000, mean beyond the base ceiling, were kept out of the pension scheme. The earlier members who were contributing on her salary were given an additional burden of 1.16 to contribute from their side on this higher in this pension fund. And it was also felt that earlier the last salary was the criteria for deciding the pension, last average of 12 months. But it was felt by the EPFO that in some establishment, people are um, the salary of the employees are inflated at the last tenure or at the last time. So just they are fetching the higher pension without contributing sufficiently a higher contribution. So it was thought by the EPFO that instead of 12 months, it should be the base of the pensionable salary must be enlarged from 12 months to 60 months. So these are the basic background on which these amended these amended provisions were brought in. Thank you.
Thank you, Mr. Pandey. Thank you, Rashmi. A lot of things, you said it. Five key changes vis-a-vis 1995 and 2014. We've got an idea, a bit of, uh, on the key changes like who become a member, who don't become a member after 2014 with a limit of 15,000, additional contribution, joint declaration, many things, and then Mr. Pandey touch upon a lot of things. I think it gives a fair idea to everyone how the scheme looks like after 2014. And Mr. Pandey specifically mentioned, there was a litigation around some of the provisions. I think in the next slides we have to take that up before we go to the, you know, concluding slides on what's next for everyone. Uh, you know, uh, I think, you've summarized the issue before this, before Supreme Court and Kerala High Court, which has brought us to the current stage where employees are looking to understand how this impact them. What are they required to do? There are many questions in everyone's mind. So, Rajshri, I would like you to, come in and take us through the decisions and what's next.
Right. Thanks, Akhil. I can actually see a lot of questions coming up on the chat, and I'll request
Yeah,
for the
yeah,
audience to bear with us as we cover the next slides and the discussion around the eligible employees, those employees who are not covered by the Supreme Court decision and the EPFO guidelines. Hopefully, a lot of those questions will be answered, but we will also then
there are
take some of the questions towards the end.
there are 30 questions, and looking into the time we have to cover everything, and if we are able to answer at that, maybe as Rashmi said, we have many things to cover, and these questions will be answered automatically. And still, if there are some unanswered questions, will respond to each one of you. Don't worry individually, and but we'll try to cover everything in this one hour. Thank you, Rashmi. Over to you.
Yeah, thanks, Akhil. Well, so in India, any legislation, there's always interpretation issues. Always it travels to the court, and that's when it leaves the layman or the common man wondering what next. Now, the 2014 amendment was brought in by the government, post which there was questions, there was interpretation issues, and the 2014 notification itself, the validity of that itself was challenged before the Kerala High Court. And after due deliberation, the Kerala High Court, in its order, which was pronounced in October 2018, it quashed the EPFO notification. So what it meant was, so from 2014 to 2018, in a way, this was pending a finality from the judicial side. So 2018 October, when the Kerala High Court decision came, the 2014 notification was quashed. The Kerala High Court, some of the key observations from the Kerala High Court was that the classification of employees based on the cutoff date, that is, new employees joining after 1st September 2014 can't be members of EPS. This is ultravires the power of the government. This is not acceptable. Second, increasing the pension limit. Third, the change in method of the calculation of pension, increasing the average period from 12 months to 16 months, 60 months. All of this is detrimental, or it'll to the employees. It'll deprive a large portion of employees from the pension that they would have otherwise been eligible for. So, taking all these aspects into consideration, the Kerala High Court quashed the notification. EPFO went in appeal, took the matter to the Supreme Court, and the Supreme Court, in its decision in November 2022, accepted and upheld most of the observations, most of the points brought in by the 2014 amendment, except one point related to the additional contribution from the member side. So the Supreme Court's observation was that the government is well within its powers to make changes in the scheme, in the minimum salary threshold. The government is within its power to increase, the pension, the change in the pension calculation formula. The central government has its power to define who would be members or beneficiaries or covered under the eligibility criteria under any legislation. So there are various observations which the Supreme Court gave, and by and large upheld the decision, the 2014 notification. On one point where the Supreme Court did not agree was where they upheld the Kerala High Court's decision and said that the requirement to contribute additional 1.16% by the members, those members who have opted to contribute towards EPS on a higher salary, that is not legal, because like I mentioned before, the contribution of the employee, the 12% as per the act, goes into the EPF. If there is any amount that needs to be diverted towards EPS, there has to be a mechanism within that. That can't be brought in from the scheme. However, what the Supreme Court also observed or came out in the decision was that uh, pending this, so they gave some time, a period of 6 months in which this additional contribution will continue, and they gave direction that the government has to come out with a mechanism to fund this amount, if at all, or they have to figure out what needs to be done to fund this amount, because if they can't make a change in the EPF Act to get employees to contribute this amount. So these were the key observations, or these was the decisions, outcome of the Supreme Court's decision.
So Rashni, if I need to summarize, on the what Supreme Court upheld is the classification and exclusion of employees, maximum pensionable salary, computation of pensionable salary based on 60 months average salary. However, one point which Supreme Court overruled the requirement to contribute is 1.16% by the members, opting contributing on higher salary, and asked the EPFO to bring an appropriate amendment mechanism for funding this amount within a period of 6 months. Am I right?
Yes, that's right.
Okay. So now over to you, Mr. Pandey. Since the majority of the amended pension schemes was upheld by the court, what are your views, and are there any gray areas which needs further clarification from the EPFO as per you?
Thank you, Akhil.
Yeah.
Actually, the Supreme Court, while delivering this judgment, has elaborately visualized many situations and answers those questions under in the judgment under para 44.
Okay.
They visualized various positions and settled the issue. However, such as there was a confusion what will happen to the person who were authorized, entitled to opt under para 11.3, and where, as per the Supreme Court judgment in R.C. Gupta, there was no cut-off date. But there was a dilemma whether they can opt or they cannot opt. So Supreme Court has provided a window in this judgment to such employees who retire, who were member prior to 1st September and eligible for the option but could not opt under para 11.3. So a additional window is provided under para 11.4 to such employees with the extension of time within 4 months, that such employees can also exercise option for contributing on higher salary. So if beside that, Supreme Court has laid down the other 3 conditions in the judgment. However, while allowing these persons who were member prior to 1st September, the Supreme Court held that the employees who retired prior to 1st September and exited from the membership will not be allowed to exercise option. So there is a gray area. There may be some person who exited prior to 1st September from the employment, but continued to be member whether they are eligible or not. As per the spirit of the Supreme Court judgment, they are eligible, they should be eligible. But the guidelines is required to come from EPFO in this regard. Like otherwise, all the issues are mostly settled, but such area are gray area. And another issue is the Supreme Court has upheld the para 26 subclause 6 and held that it is a necessary precursor. So but however, I can explain with reference to guidelines issued by EPFO that the employees who are exercising the option under para 11.4 had to provide a proof that they have exercised option under para 26 subclause 6. But historically, this rule is not followed at all in the exactly the manner in which it is provided. Always it is treated in a deemed manner, means employees and employer both had started contributing on hard salary and EPFO were accepting their contribution and without any objection. So whether this issue, even Supreme Court has not touched this point, but EPFO has to clarify and must accept the all such deemed contribution which are accepted by EPFO without strictly following the procedure provided under para 26 subclause 6, that is a joint request by employer and EPFO in writing and approval by APFC or RPFC. Historically, I can tell also, even someone has applied also, EPFO has never approved and communicated their approval. So this provision was actually never implemented in the manner in which it was provided. So some decision has to be taken by EPFO in the correct spirit of this judgment, that when it is a beneficial legislation and benefit should flow to all the eligible employees. Thank you.
I think very, very insightful inputs. I think different perspective to how the things look like. Before we move further, I would like to highlight everyone that pursuant to the Supreme Court decision, EPFO issued circulars. There are two circulars which have been issued. Everyone knows about it. It's 29 December 2022 and 20th February 2023, which provided guidelines for compliance with the Supreme Court decision. Supreme Court provided a 4-month window for employees to exercise the joint option till 3rd of March, which is further extended to 3rd of May. Everyone knows about it. EPFO was required to facilitate the compliance of Supreme Court order under an online mode. EPFO has issued the circular with guidelines to members, which provides a process by which eligible members can exercise the option under para 11.4 of the scheme that will erstwhile para 11.3 of 1995 scheme. I think it is important to note that amended EPS 2014 is squarely applicable to exempted establishments also. Now, I think everyone has this question in the mind: what is next? Can I request, Rajni or Ms. Pandey, whosoever, can take us, guide us now what's next, because we've discussed about what are the schemes 1995 historically, what it used to be 2014, what are the changes which were proposed, then litigation by at the High Court and Supreme Court level. Now after litigation, we discuss about the EPFO circulars, guidelines. Now everyone wants to understand. I don't know. I think in last 40 minutes we've discussed so many things, whether people have been able to grasp or understand what are the changes. But everyone has this thing in the mind, including myself, that was actually
yeah. Thank you, Akhil. Right. So what next? The first point is to determine whether you are an eligible employee. Now, here, the first and foremost point over here is to see that only those employees who were contributing to EPF on salary exceeding the wage ceiling of 5,000 of 6,500 before 1st September 2014, they are the eligible employees. So somebody who was already a member of EPS as on 1st September 2014, or rather actually a day before that, before the amendment scheme, and you were contributing to EPS on a higher salary, then that's the step one to determine that you are an eligible employee. So at the time of the scheme, if you were contributing on the wage ceiling, if you were contributing to EPF on the wage ceiling, then automatically contribution to EPS was also on the wage ceiling. Then you are not an eligible employee. Now, there can be further two segments or classifications within this employee base. So first, you are contributing to EPF on a higher wage ceiling, and as on the 1st September 2014, when the amendment came, you were not in service. But before that, you had exercised the option for higher contribution under para 11.3 of the 95 scheme. What this means is you had already exercised the option for higher wage ceiling. 2014 scheme came later. You had already retired or you had already left before that. Now, as per the Supreme Court decision, this segment of employees will be eligible for benefit of higher pensionable salary. And in their case, the amount will be diverted from the EPF contribution to the EPS contribution. So there is nothing that the employee has to do separately as such to allocate or contribute. The amount in EPF will be allocated towards EPS, but the joint declaration is required to be submitted, and it would be logically with the last employer where you were working. Second category is you were contributing on higher salary towards EPF, and you were continued in service after 1st September 2014 also. Right? But in this case, you had not yet exercised the option for higher contribution to EPS. So if you remember, if you can recall, the 1995 scheme gave an option to exercise, where you could contribute higher amount towards EPS. But the 95 scheme had not put a timeline by which this option needed to be exercised. So if you were contributing to EPF on higher salary, but amount going into EPS was on this wage ceiling, and you had not exercised the option under para 11.3, the current Supreme Court decision and the EPFO guidelines gives the window for us to make this contribution, make this option now, and by virtue of exercising that option, the amount would be reclassified from EPF to EPS. As per the EPFO guidelines, the calculation mechanism or the how they will do this reallocation, they are going to come out with further clarification or guidelines on that aspect. Currently, what is enabled is the option on the portal to submit the joint declaration. Right. So this also raises a question which I think some of the audience has also raised, that whether the option under para 26(6) of the EPF Act to contribute PF on higher salary, is it a compulsory option now, or it's not mandatory and employees right now can't do anything about it. Mr. Pandey.
Thank you, Rajshri. In fact, para 26 subclause 6 is a mandatory requirement because the pension fund, there is no contribution is coming directly. It is a diversion from provident fund scheme. So suppose if someone is not contributing on higher salary in provident fund, where from this amount in pension fund will come for a higher salary. So the kitty will be only from the provident fund. If you are not contributing on a higher salary in provident fund, there cannot be a higher diversion from that fund. So that is a basic requirement because that is the initial window where you have to contribute on a higher. From that, a higher contribution may be permitted to be diverted provided you are opting for a higher contribution in pension. So it is a mandatory and essential requirement under the law for contributing a higher contribution in the pension scheme.
Right. Thank you, Mr. Pandey. That helps us, put some context and hopefully answer some of the questions. Moving on, equally important for us to see which segment of employees are not covered under this decision, and there is no action point as such for them. First, like we mentioned already, to just to recap on that, employees who were contributing to the employee provident fund up to the wage ceiling. Like Mr. Pandey said, the amount over there is already only on the wage ceiling, so there is no excess amount that can be diverted to pension. So those employees are not eligible. Second, employees who are already contributing EPS on higher wage ceiling as after exercising the option under 11.3. But when the 2014 amendment came in, they did not, or they were not able to submit a joint declaration as per para 11.4, the fresh declaration to continue the additional or the higher contribution. These employees will not be eligible. I think there is a question in the audience also on this, in this regard, but that's the way the law stands, or the decision outcome stands right now, that you are contributing on higher salary, you are exercised the option and there was a higher contribution going to EPS, but in the window given by the 2014 amendment, this fresh option was not exercised. Therefore now the eligibility is not there to exercise the joint option. Second, the next category is employees who retired and exited from the EPFO membership prior to 1st September 2014 without exercising the option under para 11.3, which means that they knew, or they could have deemed to know, that they could have exercised the option, but they retired, they exited, they have withdrawn the money, so there is no further recourse in such cases. And the last category is employees who became members of the EPFO on or after 1st September 2014. This is clearly they are not members of the EPFO, EPS, and the Supreme Court decision has also upheld this part over here. Another category is the international workers. I think we have some questions on that also, because international workers were required to contribute on a higher salary in any case. The wage ceiling was not applicable to international workers. So in their case, there's no question of reallocation or diversion from EPF to EPS. So there is no action point as such. And international workers who joined after 1st September 2014, in any case, they were not member of the EPS. So international workers also no action points as such over here. Now, what we've done is try to pull in some scenarios to again validate or recap on the various points we have discussed. And I'm hoping that some of the questions from the audience gets addressed over here. Let's take the case of individuals who are members of the EPS and who retired before 1st September 2014. Now here, the Supreme Court has dealt with the situation to say that somebody who retired before 1st September 2014 and exited from the EPS membership. Now, in their case, if the EPF contribution was on a higher basis, but option was an option was exercised, not exercised under 11.3. Uh, in their case, they will not be eligible for pension on higher wages. But people who retired before September had exercised the option under 11.3. They will be eligible to exercise the option now under the amended version and opt for higher pension. Again, if these people who had retired and exited before, but were contributing on the wage ceiling, then there is no question of higher pensionable salary in that case. Here again, one small point comes in, the difference between somebody retired and exited versus somebody retired but not exited. So, Mr. Pandey, if you can just quickly help us understand the difference between somebody who retired but has not exited the EPS membership.
Thank you, Rajshri. The exited
Mr. Pandey and Ashri, we left with exactly 8 minutes and we have many things to cover. Obviously, we have 100 questions. Many of them are addressed the way both of you taken it. But in interest of time, I think let's quickly move forward further. And if needed, we can have a subsequent webinar also as a part 2. But let's focus on this. Yeah, Mr. Pandey, sorry to disturb.
So the exited from membership means the provision para 6A provides the retention of membership. Means a member who attains the age of 58 years or he receives the benefit under the pension scheme shall be deemed to have exited from membership. Otherwise, he shall be continued to be a member of the pension scheme. So Supreme Court in its judgment has dealt a case specifically those persons who retired means exited from employment and exited from membership of the pension fund, they are not eligible. But Supreme Court has not dealt the person, employees who exited from employment but had retained the membership means neither they have attained the age of 58 years nor they have withdrew the benefit under pension scheme. They are member of the pension scheme. So whether they can exercise the option, specifically they have not said anything categorically, but under para 44, 4 of the judgment, they have accepted that the erstwhile member can have a option. So in my personal view, they have a option to exercise under this option for higher contribution, but specifically EPFO in its circular has not mentioned this category, and I am hopeful that EPFO will come out with some circular to clarify this position also.
Right. Thank you, Mr. Pandey. Moving on, another scenario which will cover a large segment of employees is those who were members of the EPS before the amendment and continued in service on or after 1st September 2014 as well. Here again, we will have a large number of people who continued in service but have since then retired. That is between 1st September 2014 to date, people have retired, or there could be people who are still continuing in service. Right now, how does it look for them? If the EPF first category, criteria, if the EPF contribution was on the higher wages, if yes, then had we exercised the option under para 11.3 of the 95 scheme, we had not exercised that option. So now we are eligible to exercise the option for higher pensionable salary, and this option needs to exercise by 3rd May. Second category, you were contributing on higher wages. You had exercised the option under para 11.3. Then under the 2014 amendment, you had given the fresh option also within the 1-year timeline. Then it's fine, you're eligible for higher pension contribution. But if the fresh option under the 2014 scheme had not been exercised, then you're not eligible under the current window, right? Then another category of people, again, there are questions around this. What if there is a fragmented service, or under some employer you had contributed on the wage ceiling, but under another employer you had contributed on the higher amount? Even in this case, like Mr. Pandey said, if there is no higher amount that can be allocated from EPF to EPS, the eligibility does not arise. So those category of employees will also not be eligible under this mechanism right now. And of course, people who are contributing on wage ceiling will not be covered at all. The next set of employees are employees who became members of the EPFO on or after 1st September 2014. This, like, are covered in the eligibility criteria. Whether they contributed on a higher salary to the EPF or on the wage ceiling, it does not matter, because there is no option for them to become members of the EPS. So, we've tried to cover 6 or 7 categories over here with reference to the date from which the new amendment came in, and whether people have retired or continue to be in service, or who joined after that specific date. I think yes. So if you've determined that you are a eligible member, and you can exercise this option. So the next main question is that, should you exercise this option or not? What is in it for you? What are the pros and cons? Honestly, there are multiple factors which will decide whether you want to opt for this or not. The answer can be different for each one of us. It depends on combination of factors like, what is the tenure left for your retirement? What is your financial acumen or literacy? Whether you're looking at the lump sum amount after retirement, that is the EPF contribution, the lump sum tax-free amount that we receive, or are you looking to get a pension from the EPFO? You don't have any other source of pension, and you are banking on this as the source of pension. So that is a decision factor. Next point is the pension on survival, the pension formula over here. Some of you may be aware that it is not linked to an annuity. The EPS scheme has a formula for pension which says average of the now 60 months salary into number of years of service divided by 70. So if your tenure is longer, your salary is higher, then the pension that you're eligible to is reasonable, could be attractive enough for you to exercise this option. But here, what you need to see is, what is the tenure left? What is the risk that your salary reduces, in your next employment or the employment after that? Or if there's any other risk related to the government revising the pension formula again. So by that, in 5 years or 10 years time, there could be that potential that nobody can answer that, if the government further revises the pension formula. So that risk remains. Another decision factor is an individual's requirement to cover pension for family in case of premature death, right? So here, apart from the individual, the EPF scheme covers for pension for the spouse or the children as well. So that's also another important factor. Akhil, I think we are at 5 o'clock right now. We do have some bit to cover, and I understand from our admin team that we can extend by another 5 minutes or so. So I think
let's quickly extend it by 5 minutes, and then we summarize. I'll summarize at the end before we do. And obviously, there are more than 100 questions now. Most of them are addressed. I can see, the people have these kind of questions, which you've covered in the way forward. Today we'll not be able to take the questions. Sorry, audience, but we'll as I promised, we'll respond to each and every question over the period of time. Yeah, Rashi, let's quickly cover the coming points.
Yeah. Right. So we've taken one illustration here. Here it is an employee who joined in on 1st April 2006 with a salary of 10,000. Now this person, if we just take an average of 10% increment constantly through the year, and somebody who left on 31st March 22 after 16 years of service. Now, if the pension contribution is capped at the wage ceiling, whether it was which was 6,500, or later on 15,000. If it is capped at the wage ceiling, the monthly pension which the person is eligible is 3,429. But if the person exercises the option for higher pensionable salary, the monthly pension outflow increases by almost 4,500 to 7,900. The other side of the impact is that because this reallocation will happen from EPF to EPS, so therefore the lump sum accumulated EPF balance that you withdraw would reduce, which also means that the interest that has been credited over the last 16 years will also get recalculated, because as and when the contribution is moved from EPF to EPS, the interest will also move. And on the EPS corpus, there is no interest that somebody gets. But so this is, over here, if you see, it's in 6 years' time, somebody will recover this lump sum contribution. And if you're surviving beyond 6 years, then you're in a beneficial situation. So these numbers will differ for each one of us, and that's where one needs to think and try and do a quick back of the envelope calculation to see whether to opt for this or not. Right. Now, this is the operational part over here. Like at the very beginning, we covered the EPFO just 2 days back. They have opened the window on the EPFO portal for employees to exercise the joint option. I think the slide has gone. Nevertheless, so the option which is there on the EPF portal, employees can log in and using their UAN, Aadhaar, OTP linked credentials, they can submit their option for exercising for higher pensionable salary. This can be exercised till 3rd May 2023. This date is common for all of the employees who are eligible, whether somebody retired before 1st September 2014, after that, or continuing to be in service. Whoever is the eligible employee can exercise the option over here. Once the employee submits the option, it will go to the employer for the confirmation or for the validation, and what they've mentioned is approval over here. And once the employer also approves this from using the employer's portal. So yes, so even for the employer, this is approve the POHW request pop-up has come up here. Employer can approve this option, after which the processing is supposed to happen. And the mechanism for calculation or reallocation of the amount is again something, like we said, is awaited. There are some questions actually, or concerns which have come in from employers saying that how can the current employer possibly certify the amount which the employee is mentioning, or whatever details the employee is mentioning with respect to the PF amount or the reallocation or whatever. How can the employer certify that? Because an employee might have worked with multiple employers, might have paid less PF or more PF, there could be different permutation combinations. So Mr. Pandey, here, how do you think the employer's concerns can be addressed, or what is the intent of this employer's step process here, or employer's involvement in this process here?
Actually, there is no certification. Employer is not required to certify. It is only he is also jointly permitting to divert the fund from higher contribution from the pension provident fund to pension fund. There is no liability for employer, neither financial nor any other. Well, every data is with EPFO. Only he is consenting to divert the fund from provident fund to pension fund. He is not required to certify anything. Thank you.
Right. Thank you, Mr. Pandey. I think that helps put to rest some of the concern, because this is an option being exercised by an employee. The employer is in effect giving a consent to the diversion. If the employee is eligible, then the employer has no objection, or is giving a consent that the amount can be diverted from the EPF to the EPS. and the recalculation will happen. So I think that's the mechanical part of it. And what is awaited is the pension, how this allocation will be done.
Thanks, Rashi, and thanks, Mr. Pandey. I think it was seamlessly covered, all the changes, all the whatever the Supreme Court High Court ruling, whatever is the way forward, eligibility of the employees. A lot of people have questions. As I said, there are more than 100 questions we need to address. There are questions around whether it's a retrospective, prospective, how to file the joint declaration. Can you share the checklist? Can you share the steps? There are many things which people need clarity. I think, and thanks for the patience of the participants. We have more than 1,000 participants at the beginning, and 5 minutes, we extend it by 5-7 minutes. But as I said, we'll share our comments and address all the queries you have individually. It will take some time. People have questioned that whether they will get the PPT, whether they get the recorded version of this. Yes, we will share that. Our team will share this post the webinar. And thanks everyone. We can see a lot of applause coming in for us. And in a nutshell, I think what after 2014 there was a lot of buzz around it. There's a lot of litigation around it, but Supreme Court has put this, they've cleared everything. There's a lot of FAQs which have come, which still needs to come, and and let's see what's next. But yes, obviously, next 2 months going to be excited. People have to, through this, whether they want to file a joint application, need to find out whether they're eligible, not eligible, how this is beneficial to them, and how the allocation will happen. Some people have taken advance. If the advance has been taken and they find a joint application, how the allocation will happen, they have to give this back to the EPFO with interest. Interestingly, many things needs to be looked into and worked upon. Thanks everyone. Thanks Mr. Pandey. Thanks Ashri for your time, and thanks participants. Will looking forward to interact with you in the coming month. Maybe once we have more clarification on this, once we have more inputs to share, we'll come back with another series of webinar on the same topic. Thank you.
Thank you everyone. Thank you.
Thank you.
Thank you, Mr. Gupta.